SJC-12530, Commonwealth v. Richard Sherman.
Mr. Crane, good morning.
Good morning. Good morning. May it please the court, Edward Crane on behalf of Richard Sherman. This case asks how the jury should be instructed on the elements of rape when there's a question as to whether the victim initially consented to sexual intercourse. It's a defendant's position that the jury must be instructed that if they find that the victim initially consented to intercourse, then they must also find that the victim communicated her withdrawal of consent to the defendant in order to find him guilty of rape. This position is supported by a wealth of case law. Numerous state courts have considered this issue, and they have unanimously concluded that the victim must communicate her withdrawal of consent in order for the defendant to be found guilty of rape in this scenario.
Now, how many states have done that?
By my count, five states.
That's not overwhelming, is it?
Not overwhelming, but they've all come to the same conclusion.
So we have the strange situation that your brother actually agrees with you as to that, but he says you never asked for that instruction, and it was not a substantial risk of a miscarriage of justice, because how could a jury find that the defendant used force to forcibly engage in the sexual intercourse if he had no clue, or if he thought that she was consenting to it?
Well, I think that if there's initially consent, and then for instance, in this case, say the jury believed that her aspect of the incident, that he was on top of her, and say that it's initially consensual, but then at that point when he gets on top of her, she at some point changes her mind and is either not enjoying it or is experiencing pain, and then does not want to continue. But the fact that he's on top of her with his arms holding her down, that force compels her to continue. I certainly don't think that just because the jury found force, that inherently that means that she must have communicated her withdrawal of consent at some point. And I think another point with respect to that is, why would these courts all conclude that there has to be this withdrawal of consent if if that was somehow inherent in a force finding?
Well, they have different statutes, don't they? I mean, we have very specific case law, very specific statute.
Yes. But I reviewed some of those statutes, and it seems like all of those cases also, they have statutes, rape statutes, that involve a finding of force.
As we've defined it?
Yes.
And how have we defined it? Refresh me. How have we defined force?
We've defined force. It's a little unclear, but there are statements in the case law that the force can be just that amount of force necessary to achieve penetration.
Only if she's unconscious.
I think it's somewhat unclear as to whether that's confined to that.
I don't think it's that unclear. Those cases all involve somebody who, I think they've all been women, but who, because of drugs or alcohol or whatever, are unconscious, and then have the person imposes himself upon her. And there we've said it, but not when the person is awake and engaged and involved. There we have said, no, you need it to be by force and against her will, or by threat of force.
Well, I think if that's the position with respect to the case law, then I think certainly that principle should be extended to all rape cases. And I'll just put out a hypothetical. I mean, if two people agree to have consensual intercourse, and then the victim says stop, but doesn't physically resist or anything, and the defendant solely just continues to have intercourse with her without, say, holding her down or anything like that, just continues to intercourse.
But why should that be the rule? Why?
I think that...
Why don't we flip that around and just say the presumption should go the other way?
I guess,
in any encounter like that? Aren't we just looking at it from an aggressor perspective?
I think that, I just, in that situation, I don't see how we don't conclude that that's rape. I mean, I think if a victim says stop, but the defendant simply just continues with having intercourse with her.
Didn't we say no means no in Kennedy?
Yes, yes, and I think that,
So,
if
so
no-
what more would you look for
in what sense?
in effective communication of no?
Well, I don't think there's any, the issue in this case is not whether, there
Or
was
stop.
effective communication or not. The matter is, the fact that the judge did not instruct the jury that they had.
Instruct- So how, but how should they be instructed to, if you, what would be the proper instruction?
I think that the California model instruction is perfect.
How about the Robinson instruction in Maine?
I think that one works as well. I think California, it's laid out in a model jury instruction, and I think that it covers that additional aspect of a reasonable person must understand the words or acts to constitute a withdrawal of
But
consent.
I think, and as the chief pointed out, the Commonwealth's in agreement with you on this point, I think.
Yes,
Right? So the question is, you had a jury question, the judge answered it with reference to force, and then there was no objection to what the judge did. So now you're in a substantial risk world,
yes.
right? So how are you harmed?
I think that the primary things we have to look out at with respect to substantial risk are, first off, the fact that the jury asked the question itself suggests that the jury is, at least some of the jurors were considering this scenario in which the victim may have initially consented and then withdrawn
Was
her
there any
consent.
evidence of that?
There's evidence, I think, that you could, if you look at both persons' version of events, and, the jury's free to believe some of the testimony and disbelieve other aspects of the testimony, I think that they could certainly, they could have believed him that the sex was initially consensual, and then, believed her aspects of the version of events that, that aspects of the sex were not consensual.
How was he prejudiced?
How is he prejudiced? He's prejudiced because essentially the jury's re-instructed on the standard elements of rape, and they could find, just applying those standard elements of rape, that they could find him guilty simply in a situation where he continues to have sex with her after initially, so it was, the victim has initially consented, and then she changes her mind. She does not communicate the withdrawal of consent to the defendant. He continues to have sex with her, and solely the force involved in him having sex with her compels her to continue.
So for the first time, you want an instruction that puts a burden on the woman to do something affirmative.
I think that yes, I think, I hate to say that the burden is on the woman. The burden's, in a trial aspect, the burden's on the Commonwealth to prove that there's some sort of communication of withdrawal of consent.
Some
But
sort of communication. What kind of communication? Verbal?
it could be verbal, it could be acts.
Like what?
I would think that, simply a push to, aggressive push
She has to
to
do
push the
something
person away.
affirmative. She has to do something affirmative, as opposed to just being a victim of aggression.
Yes, and I think that's,
I thought we said that we're not going to make rape victims have to fight back to be raped. Didn't
Well,
we say that?
we have said that, but this is clearly a unique scenario that we're dealing with in the sense that the victim has initially given consent. So I think that's what takes this sort of factual scenario out of the realm.
There wasn't
of
evidence
those
of that
cases.
directly. The jury would have had to disbelieve her testimony in part and believe his in part.
Yes,
And that could happen anytime.
yes.
But this is not unusual.
I don't think it's necessarily a factual scenario that I would say would be a rarity.
No,
I
so
think
then
we've-
we'd be changing the jury instruction to have the woman have to do something affirmative.
But I think that's only in the case only in a case where,
Only in a case where the jury asks a question about it?
no, I think it's only in a case where, so I understand what Your Honor is saying in the sense that, so do we have to give this instruction in every case where there's, one side says it was consensual? Yeah, exactly. And I think that, the instruction would have to be given, but the instruction includes, there's a prerequisite. The victim, the jury initially has to find that the victim initially consented to the act before having to do this process of considering whether the victim withdrew her consent. The jury first has to find that she initially consented. So I think that's going to be, in many cases, I think that the victim, the jury's not even going to consider this question as to whether consent was withdrawn, because they won't go down that road, because they'll find in the first instance that.
Don't you think at a minimum, there'd have to be some testimony of withdrawing consent, or that the jury's asking a question so that they believe from the evidence that that's an issue rather than in every single case? That's he said, she said? I mean, that's a little concerning. Do you know if in Maine they do it in every single case, or only when either there's evidence that the victim revoked the consent, or a question from the jury indicating that that's a factor that they're contemplating?
Yeah, it's an interesting question, and frankly, I just, I don't think that, I don't know where to draw the line. I don't think this case requires that we draw the line as to, when this instruction should or should not be given. I just think that, clearly in this case, it should have been given, because the jury is specifically asking this precise question about when can it be considered rape if the victim has initially consented but then changed her mind?
What is the consequence if we're to find substantial risk that the jury question asked, does it include if she says no in the middle, which implies communication? So one of the reasons perhaps why there was no discussion with regard to the instruction as to whether it was communicated is that the jury implied that there was communication. She says no in the middle. So nobody asks for something on that issue. The jury itself suggests that arguably, what if there was communication? So why are we to sort of say that the absence of saying if there was communication, there has to be communication, and the failure to include that language means that he gets a new trial?
Well, I don't think that we can just assume from that aspect of the jury's question that they had found that she had communicated her withdrawal of consent.
Well, I agree you can't find it, but you're suggesting that the fact that they asked the question suggested at least one juror thought this arguably could be the situation. But if you take that same reasoning, however that juror or jurors were, that juror understood that it would have to have been communicated. If she says no, the language, does it include if she says no in the middle?
So the question does go on and speaks to just her changing her mind, which suggests that maybe there's no suggestion of communication there. And I think that we also have to look at the jury's verdict too. The jury did acquit him on one charge, so I think that it's certainly reasonable based on the question and the verdict itself to believe that, look, the jury believed that his aspect of the testimony with respect to the oral sex, and that was consensual, and then that they engaged in the other acts may have begun consensual, but then did not, that she did not want to continue with him.
Or maybe the jury found that the presence of blood on his fingers was confirmatory of the digital rape, and the presence of blood in the sheets was confirmatory of vaginal rape, and since there was no blood associated with the oral rape, said we're not so sure.
Well, I think that the blood, I don't think is strong evidence either way, because she's testified that she's she was having her period, so there's going to be blood involved, regardless as to whether it's
She had a
consensual.
couple of tampons in, didn't she?
She did.
Uh-huh. Where's the blood then? From her?
Well,
Is force defined in the instructions? Yeah, I mean, because,
they speak to physical force, constructive force.
I mean, in these particular instructions, did the jury, I mean, you're sort of positing sort of an ongoing act of sexual intercourse and confusion about whether that's force or not. Was the jury defined, given some explanation of what force is? Is there standard instruction on that?
They were given the standard instruction, but the standard instruction is somewhat,
Uses the word force?
yeah, it's physical force, threats. So it's a little vague. I think certainly that, you know, that instruction's been in place for a long time.
Right.
And I don't think that a jury that hears that instruction is necessarily going to include that this force has to be some sort of force that goes beyond, you know, that necessary to achieve penetration. I think they could, you could be confused as to whether it requires additional force or whether just that force necessary to achieve penetration is enough to.
But there's two distinct parts of that element, force, and then it also has to be, or the threatened use of force, and against the alleged victim's will. So
Yes.
that element has two distinct aspects to it, doesn't it?
Yes.
Yeah. And does that matter as it relates to the judge's instruction to the jury after the question?
I don't think so. I mean, I think that he did, you know, he correctly restated the standard elements of rape. And I think there's nothing wrong with his instruction in the way that he, in his restatement. I don't think it's more that he omitted what we have to adopt as a necessary element in these what we'll call post-penetration rape cases.
Did he say, though, and my memory may be wrong, did he say that if there was a lack of consent, that the intercourse continued by force or threat of bodily injury and against the alleged victim's will?
I don't believe he said anything about it continuing. I'm not exactly sure, but I'm pretty sure he restated the standard the elements without sort of trying to put it in the situation of post-penetration rape. He said lawful sexual intercourse can become unlawful sexual intercourse.
You have to admit this is a unique case in which you have text messages where she's warning him ahead of time she's not going to have sex with him.
Yes.
That's in black and white. So I'm having trouble with the substantial risk argument.
I'd say the strongest point on it being a substantial risk is again the jury's verdict, because the fact that the jury acquitted him of the oral aspect of it, I think strongly suggests. I mean, I think the only conclusion that can be reached is that they found that was a consensual act, because both parties testify that oral sex occurred. It's not a question as to whether it occurred or not.
They didn't necessarily have to find that they believed it was a consensual act. They just had to find that the Commonwealth didn't prove to a moral certainty that it wasn't. That's a big difference.
True, but I think that has to be the only basis for acquittal with respect to the oral sex. So
But the chief's point about, jurors crave corroboration, and there was corroboration for the other two. I thought that point might be an explanation.
there was a corroboration that they occurred, I think, but really here there's no dispute that these acts occurred. I mean, the only issue at trial is consent. I mean, both parties agree that these acts occurred. It's simply a matter of whether they were consensual or not.
All right, thank you.
Thank you.
Mr. Steinfeld.
May it please the court, Kenneth Steinfield for the Commonwealth. In order for this court to find a substantial risk of a miscarriage of justice, it has to make two determinations. First, that the jury believed that they were permitted to find the defendant guilty of rape if they found that there was initial consent, and then thereafterwards the victim changed her mind and did not consent, but did not manifest her withdrawal of her consent in any way to the defendant. And secondly, a serious possibility that this jury actually did that. And I don't think that either is true, largely because, as has been pointed out, the use of force element, and this goes to some questions from Justice Kafka, while the instructions do not talk about what force means, they use the phrase repeatedly, physical force to compel the intercourse. So that obviously means something more than just the force necessary to achieve the intercourse, which, as Justice Gant says, only applies when the victim is insensate.
Can you help me with your concession that it would not have been wrong for the judge to, so you concede that if raised by the evidence, and there is an issue of withdrawing consent in the middle of an act, right? How do we craft an instruction that doesn't encompass every single he said, she said case?
Well, I think that, first of all, such an instruction would not have been an abuse of discretion in two circumstances: when the evidence raises it, or when the jury raises it. So they're clearly.
So when does the evidence raise it? When there's evidence that consent is given, then withdrawn? Is that the rule?
Yes. Pardon me?
Is that the rule, that it should be the instruction should be provided when there's evidence that consent had been given and then withdrawn? And then the question is whether it was communicated.
Well, I don't think that it is or should be necessarily a rule, but I'm saying a judge would not have been amiss if he gives that instruction when the evidence raises it, such as when there are several cases in which the victims are prostitutes and the act starts out consensual, but then later becomes something other than that. So there's no question that there's initial consent in those cases, and it's obvious. Same as in the Babi case from Maryland, when you have teenagers who are fooling around in the back of the car, and there's a lot of ambiguous statements. Some can be seen as consent, so it's clear that there might be initial consent in those cases. So when that happens, or when a jury asks the question, and I agree, I don't know why this jury asked this question. I have a hard time figuring out when exactly they thought during the time frame of this event she withdrew her consent. I don't know, but there's no doubt that they asked a question about it. But of course, we don't know whether that was the entire jury or just one juror. But I think in those circumstances, a judge can tell them that she cannot just change her mind in her mind alone if she's consented initially. And I, on purpose, did not propose an instruction, but on pages 37 and 38 of my brief, I do talk about that if there is, it should be a minimal. And I point the court to the Sherry case, a famous case from this court where the court said that any resistance is enough when it demonstrates that her lack of consent is honest and real. So I think some variation of that any communication, however small, however slight, if I might say, either through words or gestures or language or something, a judge could instruct that there has to be some evidence of that for them to find him guilty.
But I guess my problem is, wouldn't there always be evidence of that, as here? I mean, he said it was all consensual. She says it was not. And so the jury comes back and says, well, we believe part of it and don't believe part of it. You know, it's so that I don't understand why it doesn't cover every rape case.
Well, we're just talking about when there's initial consent and then there's withdrawal. If it's against your consent by force from the beginning.
Is that going to be raised by the evidence?
Well, or by.
By the evidence? Because it wasn't raised by the evidence here specifically.
Absolutely not, but it can be raised by the evidence in some cases.
Well, that's
but it certainly was not here. And when it is in those cases, then I'm saying that it would be appropriate or not amiss.
Appropriate, but it's not appropriate here?
Absolutely not, because the evidence did not raise the issue.
Okay.
So no instruction when it's all or nothing?
Well, unless the jury asked the question. I think a judge might, in his discretion, say, given the facts and circumstances of this case, because the jury has expressed an interest in this question, even though I'm not sure that the evidence raises it, I'm going to further instruct them. Doesn't have to, but can in those circumstances. And I think that's exactly right. The evidence doesn't raise it, but someone in the jury room is thinking about it. So a judge could have done what these other courts have said the judges have to do when the issue is raised, but I don't think he has to, and especially not in this case, given the circumstances, and especially the repeated statement that the Commonwealth still has to show that he forced to compel sexual intercourse, which the jury knew throughout that they were going to have to find in order to convict.
And that phrase appears in the instructions repeatedly, forced to compel?
Yes, that's in the instructions.
On page 19 of your brief, you
Yes.
cited.
And I think I even bolded and italicized.
You did bold it, because otherwise we would have missed it.
Yeah,
And
well,
so,
that's my practice.
yes, if
I
you don't
missed
bold
it.
something,
I'm
then
very
you can-
insecure, so I want the court to
I appreciate
know what I
that.
think is important.
The strange part of this case is that actually it's the Commonwealth. If a juror believes that she had consented at the time of penetration, the Commonwealth needs an instruction, because otherwise the jury would be a hung jury, because the instructions to the folks say the Commonwealth must prove beyond a reasonable doubt that at the time of penetration, the victim did not consent. That's the traditional
Right,
instruction.
right,
So
but
if
penetration means the entire act, not just the initial
Well, it may be, but but generally it's understood to focus on the moment of penetration. Did the victim consent? That's the usual instruction.
Yes, it is, but I think that it's common understanding that consent does not last throughout the entire.
Right, well, I understand,
Act
but but in the
automatically,
absence of the instruction that you're describing, which speaks about what if she
Right.
consented at the time of penetration and then communicated in some fashion a change of mind, reasonably, a jury would say, well, at the time of penetration, she consented, and therefore,
Right, but there only has to be one moment in which there is both elements have been proved, the lack of consent and the use of physical force to compel sexual intercourse. And if that happens at any time thereafter, then it's obviously rape. But I do.
but do you agree that in general, this general instruction, which is the routine instruction, is fine?
Oh, yes.
Unless we have a situation which raises this issue of what if there initially was consent and then consent was withdrawn? Then and only then do we need to
Yes, that's.
say, well, yeah, it's at the time of penetration, but if during the course of the penetration there's a communication of a withdrawal of consent, then the person has to unpenetrate, basically.
Yes, I agree. I don't have any problem with the instruction as it is given in an ordinary rape case or a standard rape case in which this is not an issue. I don't have any problem.
That's the situation in other states like Maine, and we cited the Robinson case in California, that there's no reason to give an instruction of what happens if consent is withdrawn unless the evidence is, that issue's raised by the evidence or reasonably raised by the jury.
Well, I think that's correct.
Was it raised by the jury here?
Yes, they asked a question about it.
They should have gotten the instruction?
Well, no, I don't think they should have. I think the judge could have, but they were not automatically, that he didn't have to. The instruction he gave was sufficient to answer the question that they posed, which is, of course, the standard. He properly re-instructed on the elements, and those elements precluded a finding of guilt if the jury believed that she changed her mind and then did not convey in any sense that she had withdrawn her consent. And I would point the court to the Sherman case in 2008. It's not the same Sherman, where the court talked about that rape is not just a technical term. It is a term known by laymen, and I think that it can fairly be said that an ordinary person would not believe that it was rape if somebody had consented and then just in his or her head says, well, I don't consent anymore, but continues to act as if she did. I think that goes against the standard understanding of the word rape as jurors understand it, especially in light of, as Chief Justice Gantz has pointed out, the second part of the question, which was if she says no. So that's clearly what the jury was thinking about here.
But if you were the judge's law clerk here, you would have suggested that the judge make clear that It
Would
has
I
to
have
be in some
suggested
fashion
it?
communicated.
I'd have said you can if you would like, Your Honor, but I don't think you will abuse your discretion if you don't.
Is that introducing a knowledge element that we've never done before?
I'm sorry, I didn't hear the start of the question.
So is it introducing a knowledge element that we've never,
Well, I think it comes perilously
just
close.
because I think that the question is, we've never said that there is a mistake of fact defense.
That's right, that's right. I think it comes perilously close to that, and at the same concern that you might have if there's a defense of honest mistake of defense, that you do turn it around, and there's a possibility that could occur. The same sort of problem that you would have with that.
Yeah.
All right, but I'm now confused, because I had thought you had said in your brief that the appropriate course is to give that instruction, but that it's not a substantial risk.
Yes, that's correct. But I think, as I said, this should be very, very cautious in the way that it phrases that instruction to avoid changing the fundamental law of the Commonwealth, which is that a woman does not have to resist for it to be
Right, I
a
understand that.
longstanding principle.
But I understand you to be saying that if a person consents to intercourse and then during the course of it says, I really would like this to stop, but in no way communicates that the person who doesn't know that and would not reasonably have known that does not commit rape.
That's correct. And here, I think the chance that the jury believed that they're entitled to convict under those circumstances, and actually did, is nil.
So what do you say to your brother's argument about the acquittal piece of this?
Well, I think that is a curious part of the case. We don't know why they acquitted. It might have been a compromise verdict because there was some ambiguity in her conduct. He kept referring to sex, and she went over anyway, so the jury might have found there was a possibility there. They might have discredited a portion of her testimony, and I have a totally speculative theory about why the jury did what it did, if I may share with the court, with the knowledge that it's speculation. The defense lawyer asked the victim, he said, "You didn't tell the nurse that he put his penis in your mouth, did you?" And she said, "Yes, I did." The defense counsel said to the victim, "You didn't tell Detective Conley that he put his penis in your mouth, did you?" So he implied that she had told both the nurse and the officer both about the penile vaginal rape and the digital vaginal rape, but had not told them about the oral rape. However, defense counsel did then not ask the nurse or the officer, did she tell you about the oral rape or not? So I think it's possible that the jury heard or inferred from the question by defense counsel that she had never mentioned the defendant putting his penis in her mouth, either to the nurse or to the officer right afterwards. That's one thing that's possible, as I say, entirely speculative, but I don't think that it's impossible, because she did tell the detective and the nurse about the other two forms. But those are the only explanations that I can think of for why they acquitted. I mean, they obviously have the power.
The other explanation is the one the defense counsel raises, right, which is that they were engaging in consensual sexual activity, oral sex, but that was where she drew the line, right? They could reach that conclusion, right, and be logically consistent.
Well, but it was during a point, it was in between the acts for which they convicted. So I'm not sure whether they could find that there was a line drawn at that.
Okay, I forgot the order. So the oral sex is in the middle between the two?
Well, she testified that it is vaginal, oral, digital, vaginal. And he testified oral, vaginal, no digital.
But if you accept his version of this, then it's possible, right?
Right, but his version has no digital, but they found him guilty of it. So, yes, there is some confusion about how the jury could have reached, both how they could have reached the verdicts that they did, but they were permitted to. I'm not saying that they weren't. They could credit, they could discredit. I'm not saying that it's an impossible verdict. I just think it's a bit inscrutable.
Sort of inscrutable why they asked the question based on how the evidence came in too, though.
Well, but I'm not sure why they, or where, at what point they believed that consent might have been withdrawn based on the evidence. So I think they're both somewhat inscrutable, if not enigmatic, at least. But the jury could have done what it did. And as I say, there's no substantial risk of a miscarriage of justice.
Might there be one with regard to the error the judge made with the cocaine?
Yes?
There's clearly error. in
Yes,
his-
there is error. As to the admission for that one purpose, for the purpose of showing his impairment.
But that's what he instructed the jury on. as
Well, but he
as
also
credibility.
instructed the jury that they could consider the cocaine as to his credibility, and there's no objection to that. But yeah, there's definitely error, because the Commonwealth did not introduce any evidence from an expert about the effect of the cocaine. So he should not have admitted the cocaine evidence for the purpose of showing how it might have affected the defendant's ability to perceive and to recall events.
Then what would have been the relevance of the cocaine?
Well, well,
There is
he
no
thought
re-
that it was relevant for that purpose.
I understand
He
that.
also thought that it was relevant because of his lack of credibility, because he denied that there was any cocaine and that he had
But what's the
used it.
relevance of the presence of the cocaine if it's not being offered as it relates to testimonial faculties or memory?
Well, you're absolutely right. That is, the purpose for it was shown to be relevant, was in fact relevant, but it shouldn't have been admitted because of the lack of expert testimony. So you're correct. That is what we are left for. So it definitely was error for that to be admitted. But I see your point, and I don't have a good answer for it. That's what it was admitted for, and it shouldn't have been.
All right, thank you.
Unless the members of the court have any further questions?